This is Kirkland Financial versus Firestone, and each side will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes if you so choose. This is not relevant to this case, but I try to say it every time so I don't forget. Do not mention the names of victims or children. If you would stay behind the podium and keep your voice up because we do record everything. So you ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Thank you.
Thank you, Your Honor. May it please the court, I would request that you have a 5-minute rebuttal on my argument.
Thank you.
I'm here on behalf of Ms. Firestone. She is the defendant in the case that originated back in 2008. It was filed initially in the county police court. It went through an appeal process and then was tried in July of 2019 to the bench. In that trial, we raised issues in the magistrate's findings of fact and conclusions of law that relate to that trial. It should be noted that this is the second appearance before this court. The first appearance was, I believe, in 2011, where we appealed it, among other things, for a money judgment that was granted the plaintiff at the time, city mortgage, money judgment that had no basis since my client had not endorsed a note at all, preventing them from having any claim for money damages. That said, our issues here are related to factual findings that were erroneous and also due process issues related to cross-examination and opinions by our expert. First thing on the factual errors, we would submit to the court that the most glaring of those factual errors is related to testimony by Ms. Harshbarger, who was purportedly a witness to Mr. Firestone's signature and also allegedly Mrs. Firestone's signature. That's Magda. I guess it'll make it easy. I'll refer to her by first name for the court. In any event, Ms. Harshbarger was a witness only. It was found in the findings of fact that she was actually the notary on the case. Now, the court knows that a notary has a number of other things that go with that authentication of the alleged signature and verification of identity at the time of mortgage execution or execution of loan documents. The trial court agreed in whole to that false or erroneous factual finding. Secondly, it was indicated in the findings of fact that Ms. Stemple, who was offered as a way of authenticating, or I should say, disputing the factual issue of my client's signature on the loan documents. In short, I don't know if I was clear about this, we disputed that Ms. Firestone signed the documents. She was not present at the closing. Throughout the whole case, we were rather clear about that. Further, there's an indication of Ms. Willard, the expert called by the plaintiff, that the signature was in fact Ms. Firestone's. I don't know that Ms. Willard could say that, but it was made as a factual finding in the case, and that relates to her examining exemplars and other signatures where she did opine that the signature on the exemplars and on the documents in question appeared to be the same or similar signatures. That said, I think the more important part of our case, or equally important, is the due process issues. We introduced...
Let me just take you back, Mr. Labarge, for
Yes.
a second. On that issue of the documents and what Ms. Willard testified, I read your brief as saying, it's been unclear to me on whether she was able to say all the documents seemed to have been signed by Ms. Willard, for want of a better way of saying it. Did she say some of them were clear and some of them were not clear? I couldn't tell from your brief.
My understanding is that it was harder for her to determine what the signature was on a photocopied signature exemplar or sample.
So that it went to, some of them were original and some were photocopies. And
Almost
she had
all
some
of them were
difficulty. She had some difficulty on the non-original signature.
Correct. And you bring up a point that I'm going to get to, is the fact that the original mortgage document, which is alleged that my client has signed, was not presented to the court. We asked that that be done. The court elected not to look at it, or I should say the magistrate elected not to look at it. We submitted testimony by our expert who did observe the original note sometime prior to trial that indicated she saw differences in pens and coloration in the signatures on that mortgage. Which
Your
is-
expert was not a handwriting expert, she was there for loans?
She was not. She just observed the original mortgage. She didn't give an opinion as a handwriting expert. She gave more of her opinion on the germane issues related to a mortgage and what goes into a mortgage. The importance being that she found in review of this case some documents that were allowed to be admitted, that there were missing documents that she opinioned were essential in closing a loan. Those being the truth in lending disclosure, the borrow name affidavit, and the right to rescind the loan. Now, that's important for a couple reasons. The truth in lending disclosure is something to be signed at closing. It was a letter sent by the lender at the time, or the one who assumed the loan, City Financial, that they didn't have those documents in the file, that they were, quote, missing. Now, plaintiff would argue that they were misplaced. That's not missing. Those documents are essential in closing a loan, and for that reason, there's issues related to the legitimacy of this loan.
Was the testimony, though, that those documents were signed at the time of closing?
The testimony offered by plaintiff, not those documents as much as the mortgage. There's nobody who testified that my client signed those documents at the time of closing. My client offered her testimony that she and her family was in Amish country at the time the loan was closed.
The original closing, but it was refinanced.
I'm talking about the one at issue, Your Honor, is the one in 2001.
Okay, 2001.
And that was a refinance on the original mortgage that was brought in 99.
That's what you're speaking of.
So that said, there were issues, trying to see where my time is here.
You're at 8 minutes.
Okay, thank you. There were issues related to the fact that the documents, exhibits E1 through 36, were introduced and were not admitted into evidence as not having, quote, proper foundation. Those documents corroborated what our expert, Ms. Mary Stempel, testified to about what it takes to close a loan at the time, what was compliance, what was not. Very simple. Those documents have a couple that were admitted into evidence, most were not. The plaintiff appellee claimed that they were not relevant to this loan because they weren't signed. I submitted to the court my proffer, particularly page 362 of the transcript, that they had identifiers all over them related to the loan, the date of the loan, the borrower, and what happened with this transaction. My client testified that they were found shortly after her husband's death in 2004. That's when she went to look at the loan documents. She wasn't really involved in the finances, found them in a desk drawer of her husband, and reviewed those with her father, who was a mortgage broker of upwards of 40 years or so. Now, Ms. Stempel, who was our expert, is also, or was also, a mortgage broker in the time era of this loan. Now, there were objections raised as to her being able to testify about the compliance. She was qualified as an expert in loan origination and brokerage, and her testimony, coupled with the exhibits that were not permitted into evidence, would have further corroborated the fraudulent nature of this loan. Now, I anticipate I'm going to hear from the appellee that we have no cause to raise fraud as an issue. They say the statute is run and it's irrelevant at this point. Well, the fact of the matter is there is the ability to raise fraud or an illegal contract at any time when it is an illegal contract. This was an illegal contract we submit to the court. That being the case law indicates that it may be a mortgage, but it is, quote, not enforceable. The only interest that this plaintiff has is the real property. There's no money damage that is allocated to them by sale of this property or anything to come after my client personally. She did not sign the note. The other interesting point is that that note that was signed was a balloon payment note. The evidence in that Exhibit E was sufficient to show that there was an application for a full 30-year fixed-rate mortgage. The one that was actually consummated indicates that it's a 30-year with after a 15-year balloon payment, actually compressing the indebtedness to after for 15 years. Well, what does that do to the interest? It compresses it to the front end. You make virtually no progress in the principle of the loan. And we submit to the court that this was a bait and switch. There was evidence of that fact in that packet.
Counsel, you're almost into your 5 minutes, and I'm going to ask you a question though anyway, because the opposing side is going to stand up and say, well, this is all fine and dandy, but you didn't even preserve your objections. They were not specific. I know you raised that in your reply brief, and I'm sure you'll raise it in your rebuttal, but could you explain to us what you did to, and what your client did to preserve the record adequately in regard to objections?
Objections in general, Your Honor, or
Well, the objections that you filed.
in the brief?
No, the objections to the magistrate's decision.
Well, I think initially we filed a objection to the findings of fact as being erroneous and a misapplication of the law. I think the law, as I reviewed it, shows that if you preserve the objection by raising it, it puts the court on notice that there is a problem, and in doing that, it allows the court to correct the error. I submit to the court that it's preserved in that sense, and I would also submit to the court, relative to your question, I don't think they even reviewed the transcript, and that's adequately clear by the fact that they found Stacy Harchberger, who was a witness, as a notary. It was a misapplication of fact and finding that the court rubber stamped as being the case, and it's clear in the transcript that it never happened. So related to that, I would say it'd be preserved under the law to raise it, bring the court's attention to the objections related to findings of fact.
And so your position is that you didn't have to specifically object to each finding of fact?
I would say that
Finding of fact.
I would say that some of that was done, but not in a particular per paragraph objection. It's clear by the briefs we filed.
Thank you.
Thank you.
And you have 3 minutes left, just a little over.
Good morning, Your Honor. May it please the court, Alex Getch. It's my pleasure today to represent the plaintiff appellee, Kirkland Financial, LLC, who was the successor lender to the originating lender in this case. At its heart, this is a simple foreclosure matter with a lot of undisputed facts. It was undisputed that in 2001, Steve Firestone borrowed over $285,000 from First NLC, the originating lender, to refinance a purchase loan that was a purchase money mortgage that he signed and was also signed by Mrs. Firestone. That refinance also paid off credit cards and allowed them to take some cash out of the closing, and essentially stands in the place of the money that they borrowed to buy the home that Mrs. Firestone lives in now. It's undisputed that in 2001, Steve Firestone signed the mortgage that's at issue in this case. It's also undisputed that that mortgage contains a signature of Mrs. Firestone.
Counsel?
Yes?
How can you say that's undisputed?
Well, it's undisputed that there's a signature on the document.
Okay, that's a
It is disputed who signed it.
I was going to say that's completely different.
Well, it is and it isn't, Your Honor, because that mortgage is signed. It is, at the time in 2001, the statute required that there be 2 witnesses, one of whom could be a notary, and also that it contained a notary acknowledgement, and it was recorded. And under Revised Code Section 5301.01, because all those steps were taken and that document was recorded, it bears a presumption under the law of validity. And in order to overcome that presumption, Mrs. Firestone would need to come into court with clear and convincing evidence to prove that that was not her signature on that mortgage. And at trial, skipping ahead here a little bit, the magistrate found after the trial evidence, that the testimony of Mrs. Firestone was not credible. And what Mrs. Firestone testified to was that she did not, in the original, there was a previously dismissed and now refiled, in this case, foreclosure. In that case, she never raised any defense based on the fact that she didn't sign this mortgage or that it was somehow forged. Up until sometime in the Court of Appeals, she submitted an affidavit that said I didn't sign it for the very first time in that case. When this case was refiled in 2014, Mrs. Firestone admitted at trial that she didn't include in her pleadings any denial that she signed this mortgage or that it was a forgery. She admitted in discovery responses that that it was her signature on the mortgage, and then only later, as the case developed, did she espouse this defense that she didn't sign it. Her only evidence that it wasn't her signature was frankly her self-serving testimony that for 4 hours on this day, I believe I was with my parents visiting Amish country, although she had no records to substantiate that that actually happened on, I think it was June 28th of 2001. And in contrast to that, we have the testimony of Vicki Willard, the forensic document examiner, who used her microscopes and examined the original note, the original mortgage. She compared that to, I think it was 4 or 5 signatures that Mrs. Firestone signed at her deposition, probably another dozen or so signatures from documents going back to before 2001 that Mrs. Firestone stipulated to and admitted in trial were her authentic signatures, and used those forensic techniques to compare those signatures and determine to the highest degree of certainty that the same person who signed these exemplars was the person who signed the mortgage. Now, she couldn't testify that it was Magda Firestone that signed it because she didn't see Magda Firestone sign the exemplars, so she was being careful in her testimony. But it was stipulated to and admitted that Mrs. Firestone signed those exemplars. That means that, at least according to Ms. Willard, there is, in that field of study, the highest degree of certainty that she did sign the mortgage. And the magistrate found that testimony compelling and credible. And based on that, the magistrate determined and the court adopted that Mrs. Firestone had indeed signed the mortgage, and therefore issued a decree allowing this property after almost 17 years, something like that, to finally go to sale. There's $267,000 in principal due, over $243,000 of interest, and amazingly over $100,000 of taxes, real estate taxes and insurance that the lenders have advanced so that Mrs. Firestone can live in this property without paying anything since mid-2007.
Counsel, let me ask you a question in regard to Ms. Willard. You said that she examined the original mortgage.
Correct.
But the one that was presented to the court was a photocopy.
It was a certified copy that was brought to trial. My co-counsel had, was frankly the foreclosure firm. They keep very tight controls on the original documents, the note and mortgage. Generally speaking, Your Honor, the mortgage is not a necessary document, the original mortgage.
Well, but in this case, it was.
I understand.
Alleging fraudulent
I understand.
signature.
The original note is essential in a foreclosure because the lender needs to prove that they're a holder and therefore entitled to enforce that instrument. In this case, Ms. Willard had examined the original. The original, at counsel's request, was brought up so that his expert could review it, and then it was, to maintain custody of it, was taken back to my co-counsel's offices. There was no request that it be brought to trial. There were copies, there was testimony about it. I don't frankly know, as I stand here, why it wasn't brought. I don't believe it was necessary that it be there, though.
Well, your expert, Ms. Willard, testified that it was more difficult to ascertain the authenticity and legitimacy of signatures on photocopies.
Correct, but she was not examining the photocopy of the mortgage.
Right, but I'm just asking, so the trier of fact here didn't actually see to compare the signatures to the original, only saw a photocopy.
You are correct in that, Your Honor. I think that cuts both ways. You know, we don't know what the magistrate would have determined if she'd seen the original. The documents in question that were more difficult to gauge photocopies were other related questionable documents. I believe one of them might have been the truth in lending document that was signed by Ms. Firestone. You know, there were other signatures that Ms. Willard was comparing other than the original mortgage to determine whether those signatures were valid or not. Some of those, because there were photocopies, she lessened the degree of certainty, but she was still concluded that they were signed by the same person.
Counsel, did any of the experts testify, either your expert or the defense experts testify as to how unusual it is for a husband to sign, or any spouse, to sign the note alone, but then the husband and wife both have to sign the mortgage?
Several witnesses testified that that's not uncommon at all, and it happens all the time. In this case, Ms. Firestone had no credit history. She had no income. She believed that, and she left, I think her testimony was that she left those decisions to Mr. Firestone, but she thinks that's why she wasn't on the mortgage. It's common. She does to have one spouse be a borrower on the note, but because Ohio, at the very least, is a dower state, in order for that mortgage to encumber the entire interest in the property, the other non-borrowing spouse would have to sign the mortgage. In here, where the Firestone owned the property as joint and survivor tenants, it would be required that they sign that. So that title work is what I do for a living. I see this all the time. It's not unusual. I know that's not evidence, but
Yes, I was just going to say what was presented.
yeah, Ms. Stemple agreed with that at trial. Chris Clymer from Kirkland agreed with that at trial. There might have been another estimate. I believe Ms. Harshbarger also acknowledged that at trial, Your Honor. If I could address a couple of the arguments raised, particularly with the issue of starting with Ms. Harshbarger not being a notary. That is true. It was, I would say, a harmless misnomer in the magistrate's decision that was adopted. Ms. Harshbarger was a witness. She was a notary. She did not act as the notary in this case. She acted simply as a witness. She testified that she doesn't, of course, remember this now 20 years later at trial, but that she had a very strict custom that she wouldn't sign as a witness unless she saw that the signer was being identified, their identity confirmed, and saw them sign the document. That was her testimony. And her signature appears on this document. It really makes no difference in my mind whether she's a notary or a witness. The testimony probably is the same. I doubt a notary would have recalled this anyway. But Your Honor, to your point, that I believe it was paragraph 30 of the magistrate's decision was not objected to with particularity, and I believe that argument is waived. Even if somehow raised under the catch-all umbrella of erroneous findings, I don't think it makes any difference here. We don't know. There's not been any suggestion in the briefs or today suggesting some outcome that would change the enforceability of this mortgage based
Well,
on
I
it.
think one of the arguments may be, and I don't mean to put words in the mouth of the appellee, but as I understand, one of the arguments was, well, it's not just the fact that the magistrate got it wrong, that she was not a notary but was a witness, but in fact, the trial court in adopting those findings didn't figure it out either.
Well, that is true that the trial court echoed that, but I believe if you read the trial court's decision as a whole, many of which will simply regurgitate the actual magistrate's decision, and often they're drafted by foreclosure counsel. That wasn't at all what happened here. We had a decision, magistrate's decision completely crafted by the magistrate, and a lengthy analysis of that performed by the trial court that walked through every step. If reading that trial judge's order adopting the magistrate's decision as a whole, despite this mischaracterization of Harshbarger as the notary instead of a notary who was just a witness on this mortgage, I think it's clear that the judge did review this and not just stamp her name on this, so to speak. That same failure to raise with particularity and therefore waived on appeal goes to the argument that I believe it's in paragraph 31, that Stempel did not testify to authenticate Ms. Firestone's signature. That's true, she didn't. She wasn't offered that. Counsel made that very clear when Ms. Stempel took the stand that that wasn't her purpose. So again, that doesn't harm anything in any way. It's just perhaps an interesting way to state it in the opinion. I think that the biggest things we see here are this allegation that there's some missing documents. We have the documents. They're signed truth in lending statement. There's a signed right to rescind. They were produced at trial. And so what if they weren't? As counsel noted, yeah, those claims are time barred. RESPA and truth in lending, which are the only two statutes that Mary Ruth Stempel argued were somehow violated, although she couldn't point to any specific provision. She'd been out of the business for 10 years at least at that time. Those federal statutes and regulations don't provide anything that would say the failure to comply with those would affect the validity or enforceability of the mortgage. And that's in 12 U.S.C. 2615. And if there were some error, those statutes provide between 1 and 3 years from the origination of the mortgage to make a claim to rescind the loan. So by 2004, when Mr. Firestone passed away, any rights to address any alleged wrong in the origination of this loan, that's roughly the time that those claims became time barred, and they're not proper defenses in this case. The documents we heard quite a bit about earlier today from Mr. Firestone's office drawer, that's not what happened. Ms. Firestone did testify that she found documents in a drawer. She was never shown a packet of what were really loose papers and said, yes, these are the documents. That didn't happen at trial, and the transcript's clear on that. There was no attempt to have a knowledgeable witness authenticate those papers. So all we knew was that there were some documents that Magda Firestone found. Next, counsel attempts to have Ms. Stempel authenticate those documents as an expert witness that were not otherwise admitted in the court. As Ohio law is quite clear, or Ohio evidentiary laws, an expert cannot testify to facts that aren't an estimate or aren't in evidence, and that's exactly what the situation we had here.
Counsel, you need to conclude.
Your Honor, absent any further questions, the trial court properly concluded that Magda Firestone executed the mortgage that's at issue in this case. The undisputed evidence was that Kirkland Financial was entitled to foreclose on the note mortgage, was entitled to a decree and the ability to sell this property. Nothing that's been raised in this appeal should disturb that decision and allow this foreclosure to go to conclusion. Thank you, Your Honor.
Thank you, ma'am.
You have 3 minutes and 5 seconds, and you're getting 30 extra seconds because you went over a little bit.
Thank you. Your Honor, a couple things raised by counsel. Firstly, it was requested that the court actually examine the original note or mortgage. That was germane to this whole case. Was it actually my client's signature? Did she agree to the mortgage? There was testimony introduced that would at least elicit the court to decide to review it. She had indicated at the conclusion of the case that she may review it, and apparently never did. That said, I would also take issue with counsel's characterization that Ms. Harshbarger was not a difference between being characterized as a witness versus a notary. I think I mentioned to the court the notary has a higher standard and obligation on the signing of a mortgage. That's verifying the identification of each person signing on that mortgage, and that usually comes with an ID and other trappings to verify they are who they are. So I think that's not a proper finding of fact, and the court did not catch it. Further, the missing documents that counsel has indicated, so what? are indicative of a problem loan. This isn't the normal course. I think that was testified quite clearly by Ms. Stemple, that these are essential for closing a loan. The fact
Don't they
that,
have to first be authenticated by someone who could say, here's where they are, and here's where I found them? Isn't that the issue the trial court was?
I think these ones I'm referring to, Your Honor, are admitted into evidence.
Okay,
It's the truth in lending,
okay.
they're admitted into evidence, they're included with that packet as well, because that's where they originally found,
Okay.
including the letter that was 21 days following the closing of the loan saying, hey, these are missing, could you sign them for us?
Okay.
So that said, I think it goes to the type of loan that was signed. There was testimony that it wasn't actually what Mr. Firestone was after, that it went from a 30-year to a 15-year with a balloon. That said, so what is what? It's something that's important. It goes to how was this loan originated? Is it valid? The fact that certain statutes have run related to claiming money damages or rescinding, it's probably true. This was formulated in 2001. In 2004 is when we discovered this. We can always assert a illegal defense or a fraud defense in enforcement of a contract. That's what this is. And we're asserting that today and have been since this case was refiled in 2014.
Counsel, could I ask you, I just want to make sure I'm understanding, obviously we'll go through the record with a fine-tooth comb, but the letter that was sent about the missing documents, didn't it say at first the documents were signed at closing?
No, not at all. And I appreciate your question on that, because it was very clear they were missing. They didn't indicate they were signed and misplaced. As characterized by counsel, they were missing. They weren't signed, is what we would submit to the court. So as far as that goes, we would ask the court to consider the evidence that was not admitted as having a proper foundation. It was laid by my client and her testimony about what she found, and also corroborated by our expert, Ms. Stemple, on the day of trial, which would have been the second day of trial. I thank you, and I ask that you would take this under due consideration.
Thank you.
Thank you for your time.
You both did well, you ended at the same exact time. All right, thank you both for your presentations to the court. The court will take the matter under advisement and will issue a written opinion, which will be sent to both sides, as well as the court releases all of our opinions electronically on the Supreme Court website. Thank you.
Thank you.